Where their sentences are on hold.
When and even if their executions can proceed is now in the hands of the state Supreme Court. State House reporter Mary Green has those details.
On Tuesday morning, the South Carolina Supreme Court heard arguments in a challenge brought by 4 death row inmates against 2 of the state's methods of execution, the firing squad and the electric chair. But a new state law also had their attorneys raising questions about the third method, lethal injection. Attorneys representing 4 death row inmates who have run out of appeals say the electric chair and firing squad violate the state constitution's ban on cruel, unusual, and corporal punishment. State law allows death row inmates to decide how they're put to death.
Other states, they're not electrocuting people, and they're not shooting people. Somebody shouldn't be able to elect an unconstitutional method.
Inmates' attorneys concede they believe the third method, lethal injection, is lawful, but they question how it can proceed through a new state statute called a SHIELD law. It allows the identities of drug makers and pharmacies to remain hidden from public disclosure if they provide South Carolina with lethal injection drugs, which the state now has. The Department of Corrections says it hadn't been able to acquire them since its last batch expired about a decade ago, before the SHIELD law was enacted.
The individuals are entitled to some information about the drugs. And I'm here on behalf, I think, of their interest to make sure that it is as humane as possible.
Attorneys for the state cautioned the court to be careful if it orders the Department of Corrections to reveal additional information that the SHIELD law is designed to hide.
If too much is disclosed or is disclosed in the wrong way, it will thwart the efforts of SCDC moving forward to obtain the drugs, and lethal injection will once again in South Carolina become unavailable.
And they contend the Supreme Court should uphold the constitutionality of the firing squad and electric chair.
The United States Supreme Court, in talking about the prohibition on cruel and unusual punishments, has said that the Constitution does not guarantee a painless death, and that, as it put it in Bayes, pain is an inescapable consequence of death.
There's no timeline for justices to issue their ruling, but until the court rules otherwise, the state will not be allowed to carry out any executions, something it hasn't done since 2011. Reporting Columbia, I'm Mary Green.
A lower court judge has previously ruled that the firing squad and electric chair are unconstitutional as cruel, unusual, or corporal punishment, but attorneys for the state argued that ruling was wrong.